Consultation on the reform of the MACC. First of all, I'd like to start off by thanking the various organizations who are involved in the drive for reform of the MACC and for this evening's event. Ideas, Transparency International Malaysia, the Center to Combat Corruption and Cronyism, the Citizens Network for a Better Malaysia, and of course the Bar Council. Ladies and gentlemen, it is my pleasure to welcome all of you here this evening. There is a perception among Malaysians that corruption is common in our country, present at all levels of society. According to the Corruption Perception Index by Transparency International, which ranks countries according to how their public sector is perceived in terms of corruption, Malaysia was ranked 52 out of 175 countries in 2014. The year before that, 2013, Malaysia was ranked 53 out of 177 countries. And the year before that, 2012, Malaysia was ranked 54 out of 176 countries. 10 years ago, Malaysia was ranked 39 out of 158 countries. Thus, it would appear that the situation in Malaysia has not improved over the past 10 years. The Malaysian Bar views corruption as a matter of serious concern because corruption undermines the rule of law, denies the principles of fair competition, misuses public funds, entrenches bad governance, hinders efforts to eradicate hunger and poverty, degrades our environment, harms human health and well-being, and contributes to instability and human rights abuses. In short, corruption harms people's lives, damages our economy, and destroys our natural environment. If Malaysia is to realize our aspiration to be a truly developed nation, to be advanced politically, economically, and socially, and not merely have the appearance of a developed nation, the elimination of corruption in Malaysia must be given high priority on the reform agenda, which is why we are gathered here today. The Malaysian Bar would like to seek public feedback on reform proposals with respect to existing anti-corruption laws for the purpose of enhancing the MACC's ability to combat corruption. Over the last few years, the Bar Council has been engaging with the MACC in general, and particularly with Tan Sri Abu Qasim, the Chief Commissioner of MACC, Datuk Sri Haji Muhammad Shukri Abdul, the Deputy Chief Commissioner in charge of operations, and Datuk Mustafa Ali, the Deputy Chief Commissioner in charge of prevention, on issues of fighting corruption. They too are desirous of strengthening the MACC. I take this opportunity to record my thanks to them for having been most welcoming and open to such engagement with the Malaysian Bar. 8 months ago, Tan Sri Abu Qasim and the MACC approached the Malaysian Bar to seek our feedback to their desired reforms to the institution that is the MACC, as well as the MACC Act, so as to fortify the MACC's ability to combat corruption. Subsequent to that, the Malaysian Bar engaged with the MACC and civil society organizations to discuss the aforementioned proposals and to formulate more comprehensive proposals that can address the greater challenge of eradicating corruption in Malaysia. This led to the Malaysian Bar collaborating with ideas, with support from Transparency International Malaysia, the Center to Combat Corruption and Cronyism, and the Citizens Network for Better Malaysia, to address the challenges of corruption in Malaysia. We also sought the views of other civil society organizations such as the Malaysian Center for Constitutionalism and Human Rights, the Penang Institute, SINA Project, and Bersih 2.0. I take this opportunity to thank them for the comments, ideas, and feedback that they have contributed. The result of all these discussions is a set of legislative and institutional reform proposals that we have outlined in a memorandum that we will share with the public today for your views. This memorandum contains proposed next steps in the continuous improvement of the MACC and the fight against corruption. These proposals are but part of a gradual and progressive evolution of anti-corruption efforts that have been taking place even before Malaya gained independence. In 1950, the British introduced the Prevention of Corruption Ordinance 1950 to replace previous laws related to corruption in the Federated Malay State, the state of Johor, and the Straits settlements. In 1959, as a young nation, the newly formed government of Malaya established 2 units working under different departments to tackle corruption. There were the Criminal Investigation Department, Special Crime, under the Royal Federation of Malaya Police, now known as the Royal Malaysian Police, and the Corruption Prevention Unit, under the Prime Minister's Office. Meanwhile, prosecution was carried out by the Attorney General's chambers. In 1961, the Prevention of Corruption Act was passed, allowing for the establishment of the Anti-Corruption Agency, otherwise known as the ACA, under the Ministry of Home Affairs. The ACA began operations formally on the 1st of October 1967. In 1973, the ACA was restructured and renamed as the National Bureau of Investigations in accordance with the passing of the National Bureau of Investigations Act 1973, becoming a full-fledged department under the Home Ministry. The NBI's task, the National Bureau of Investigations task, was not only to enforce the Prevention of Corruption Act 1961, but also to enforce the 1967 Customs Act, the Penal Code, the 67 Police Act, and the Emergency Ordinance. In 1982, in a move to create a specialized body to address corruption in terms of its role and functions, the Anti-Corruption Agency Act 1982 was enacted, and the National Bureau of Investigation was renamed as the Anti-Corruption Agency. In 1997, the Anti-Corruption Act was enacted. It replaced the Prevention of Corruption Act, and it granted the ACA the powers to investigate, interrogate, and arrest offenders of both private and public sector corruption. The ACA was also given the power to access documents and question witnesses as they felt necessary, freeze assets, seize passports, monitor income and assets, and propose administrative and legal reforms. Thus, the ACA was able to adopt a more comprehensive approach toward eradicating corruption. In 2008, the government repealed the ACA Act of 1982 and replaced it with the MACC Act of 2009 that outlined the establishment of a commission to be known as the Malaysian Anti-Corruption Commission, MACC, replacing the ACA. According to the MACC Annual Report 2009, the MACC was established to enhance the effectiveness and efficiency of its anti-corruption efforts, as well as to improve perception of independence and transparency of the functions of the Commission. To improve the MACC's transparency and professionalism, as well as to address public perception with regard to its work, check and balance mechanisms were established in the form of 5 independent oversight bodies whose ambit is to closely and constantly monitor the functions of the MACC to ensure that the functions and roles of the MACC are implemented efficiently, effectively, and independently. The 5 independent oversight bodies are the Anti-Corruption Advisory Board, the Special Committee on Corruption, the Complaints Committee, the Operations Review Panel, and the Consultation and Corruption Prevention Panel. The first 3 independent oversight bodies mentioned are established by statute, whereas the last 2 are established by administrative order. The membership of these 5 bodies is intended to be representative of the interests of the general public and consists of people who are of high caliber and good standing in society. The functions of these 5 oversight committees are important for good governance and as check and balances for the role and functions of the MACC. So 2 weeks ago, on the 23rd of February 2015, the Prime Minister announced 26 new appointments to 3 of the committees. That is, the Complaints Committee, the Operations Review Panel, and the Consultation and Corruption Prevention Panel. We look forward to the work of these 5 committees in fulfilling their respective functions. Altogether, there are 45 individuals sitting in the 5 committees currently. Of these 45, 10 of them are ex-senior government officials, 10 are academicians, 8 are from the corporate sector, 7 are current legislators in the Dewan Rakyat and Dewan Negara, 4 are heads of media organizations, and 3 are members of civil society. Broken down by gender, 37 of them are men and 8 are women. It is the Malaysian Bar's hope that the membership of these 5 oversight committees will be further strengthened in the future by featuring more members and leaders of civil society and more women as well, for greater diversity of views, expertise and background. Ladies and gentlemen, there is a structural weakness, as you would have noticed from my recitation on the evolution of the ACA into the NDI, back to the ACA, and then into the MACC. There is a structural weakness in the MACC. It does not have the power to recruit its own staff and has to draw their staff from the common pool of civil servants as mandated by the Public Service Commission and administered by the Public Service Department. The MACC does not have the ability to directly recruit, interview and employ candidates who in their minds have the requisite qualities to be officers of MACC. This makes it difficult for the MACC to employ officers who are independent and able to investigate allegations of corruption of other civil servants without fear or favour. Further, the Chief Commissioner of the MACC does not have security of tenure. Although he or she is appointed by the Yang di-Pertuan Agong, the service and tenure of the Chief Commissioner is nevertheless wholly dependent upon the advice of the Prime Minister rendered to the Yang di-Pertuan Agong, who is constitutionally obliged to follow and act upon the advice. These provisions do not lend to the independence of the office of the Chief Commissioner and therefore the overall independence of the MACC. Thus, it is proposed that an Anti-Corruption Service Commission be set up under the Federal Constitution to redress this, the salient features of which are set out in our memorandum. Other proposals contained in the memorandum pertain to the MACC Act to strengthen the ability of the MACC to act against corruption. For instance, it is proposed to have a provision making it an offence for public officials to abuse or misconduct themselves in public office. It is also recommended that there should be a law that governs the declaration of assets by public officials, and that it should be an offence to be found living beyond one's known means of income. It is also proposed that there should be a provision in the MACC Act 2009 to provide for corporate responsibility or liability for businesses for the corrupt acts of their employees. There are also other related proposals pertaining to amendments to the Whistleblower Protection Act, the Official Secrets Act, the Witness Protection Act, and the enactment of a Freedom of Information Law. A presentation of these salient features will be made in the course of this evening. Lastly, I wish to express my sincere appreciation to the MACC for looking to the future of MACC and for being desirous of enhancing and improving the MACC to perform its functions and undertake its responsibilities in an independent, efficient and effective manner. To all present here, I once again express a very warm welcome to you. May we have a meaningful and insightful discussion this evening. Thank you.